The Achaemenid Empire, c. 550 to 330 BCE, founded by Cyrus the Great, represents one of the earliest and most expansive empires in history, stretching from the Indus Valley in the east to the Aegean Sea in the west. The Achaemenids established a sophisticated administrative and legal system that reflected both the diversity of their empire and the need for centralized control. Unlike contemporary Mesopotamian or Egyptian legal frameworks that relied heavily on codified laws, Achaemenid law was a complex amalgamation of imperial decrees, local customary law, and religious principles. 1. Legal philosophy and sources of law. Achaemenid legal philosophy emphasized order, justice, and the king's role as a guarantor of societal stability. Central to this philosophy was the concept of far, or royal charisma, a divine authority that legitimized the king's rule and his capacity to enforce law. Unlike Hammurabi's code, which provided detailed legal stipulations, Achaemenid law relied heavily on the king's edicts, local traditions, and the moral religious framework of Zoroastrianism, the dominant faith that increasingly influenced the empire, especially under later rulers like Darius I and Xerxes I. The primary sources of law included royal decrees, daster, issued by the king to address civil, military, or administrative matters. These decrees were binding across the empire and took precedence over local customs. Local customary laws. The empire's vast size necessitated respect for regional legal practices. Satraps, or provincial governors, were tasked with interpreting royal edicts in ways that harmonized with local traditions. Religious and moral codes. Zoroastrian principles of truthfulness, honesty, and social justice underpinned legal decisions, particularly concerning contracts, inheritance, and familial obligations. 2. Administrative and judicial structure. The Achaemenid Empire was divided into satrapies, semi-autonomous provinces governed by satraps. These satraps wielded significant authority, including judicial oversight, tax collection, and military command, but they were held accountable to the central administration in Persepolis. To prevent abuse of power, the king appointed royal inspectors known as the king's eyes and ears, who monitored satraps and local judges. Legal cases were heard at multiple levels. Local courts handled minor civil disputes, land and property claims, and family law issues. Provincial courts, under the satraps, dealt with more serious criminal cases, taxation disputes, and interregional conflicts. Royal courts addressed high-profile cases involving elite officials, large-scale land disputes, or offenses against the crown. The king himself sometimes presided over these cases or delegated authority to trusted officials. Civil law in the Achaemenid Empire. Civil law encompassed property rights, commercial transactions, family matters, and contracts. Achaemenid rulers recognized the necessity of protecting private property to maintain economic stability. Legal documentation, including written contracts and receipts, was common in urban centers. For example, Babylonian and Elamite administrative tablets from the period record land leases, loans, and sales overseen by local judges. Family law emphasized the patriarchal structure of society while providing mechanisms for dispute resolution. Marriage contracts and inheritance arrangements were legally recognized, often mediated by local elders or religious authorities. Women, particularly in urban centers, could hold property and engage in commerce, although their rights varied depending on local customs. 4. Criminal law and punishments. Criminal law under the Achaemenids combined royal decrees, local customs, and moral considerations. Crimes against property, family, or the state were punished according to severity and social status. Historical sources, including Greek historians like Herodotus, indicate that the empire utilized fines and restitution for minor offenses, particularly those involving property damage or theft. Corporal punishment for more severe violations, including physical mutilation, whipping, or branding. Capital punishment for treason, murder, or rebellion against the crown. The execution methods were often designed to reinforce royal authority and public order. One of the unique aspects of Achaemenid criminal law was its attempt to harmonize justice across diverse cultural and ethnic groups. For instance, the punishment for a crime could differ depending on local customs, provided the ruling satrap adhered to overarching imperial standards. 5. Legal pluralism and local autonomy. The Achaemenid legal system was notable for its legal pluralism. While the king's authority was absolute, the empire's administrators recognized the impracticality of enforcing a single legal code across territories as diverse as Egypt, Lydia, and Persia. As a result, local courts often applied indigenous laws unless they conflicted with imperial decrees. This approach allowed for cultural continuity and facilitated smoother governance. For example, in Egypt, pharaonic legal traditions persisted alongside Achaemenid oversight. In Babylon, Mesopotamian law codes, including elements of Hammurabi's code, influenced judicial practices. In Anatolia and Lydia, local customary laws continued to govern trade and family relations. 6. Administrative justice and oversight. Achaemenid rulers took a proactive role in judicial oversight. The king was portrayed as the ultimate arbiter of justice, ensuring fairness and punishing corruption. Royal inscriptions, such as those of Darius I at Behistun, emphasized the king's role in restoring order and punishing rebels or unjust officials. This oversight reinforced imperial authority and cultivated loyalty among satraps and subjects alike. The empire also employed scribes and judges who documented legal decisions meticulously. This administrative bureaucracy not only preserved the king's edicts but also maintained continuity and transparency in governance. 7. Comparison with contemporary legal systems. The Achaemenid legal system differed significantly from other ancient legal frameworks. Unlike Mesopotamian law, which relied on fixed codes like Hammurabi's, Achaemenid law was more adaptive, incorporating local customs and royal decrees. Compared to Egyptian law, which combined pharaonic tradition with religious oversight, the Achaemenids relied more heavily on centralized imperial authority, while still respecting local legal pluralism. Unlike Greek city-states, where laws were debated and codified by citizen assemblies, Achaemenid law reflected a top-down model, where the king was the ultimate source of justice. This hybrid approach allowed the empire to govern efficiently, maintain stability, and accommodate a vast array of cultural and legal traditions. 8. Legacy and influence. The Achaemenid legal system influenced subsequent empires, including the Seleucids, Parthians, and Sassanids, particularly in administrative organization, legal pluralism, and the integration of local customs. The emphasis on written decrees, satrapal oversight, and religiously informed moral codes left a lasting imprint on Persian governance. Moreover, Achaemenid practices foreshadowed later administrative strategies in the Roman and Byzantine empires, where centralized authority had to balance uniformity with regional autonomy. The blending of imperial oversight with respect for local customs demonstrated an early understanding of legal pragmatism in complex, multicultural states. Conclusion. The Persian Achaemenid legal system was a sophisticated and flexible framework designed to govern one of history's largest empires. By combining royal decrees, local customary laws, and religious moral principles, the Achaemenids maintained order while respecting the diverse traditions of their subjects. The system's emphasis on administrative oversight, legal pluralism, and moral ethical governance allowed the empire to thrive for over 2 centuries and influenced subsequent civilizations in the ancient Near East and beyond. Ultimately, the Achaemenid legal model illustrates how law can function as both a tool of imperial authority and a mechanism for integrating cultural diversity. Sources: 1. Kurt A., 2007, The Persian Empire, a corpus of sources from the Achaemenid period. Routledge. 2. Brosius M., 2000, Women in Ancient Persia, 559 to 331 BCE. Clarendon Press. 3. The Bryant, 2002, From Cyrus to Alexander, A History of the Persian Empire, Eisenbrauns. 4. Waters M., 2014, Law and Administration in the Achaemenid Empire, in Journal of Ancient Near Eastern History, 1:1:1-24. 5. Stoneman R., 2015, Persian Empire, Edinburgh University Press. 6. Dandamov M.A., 1989, A Political History of the Achaemenid Empire. Brill. 7. Herodotus, Histories, Book 3 and Book 7.